Africa is on X.
At Africa Melane.
At the Supreme Court of Appeal in Bloemfontein today, the Social Development Minister and the South African Social Security Agency will be appealing against a judgment of the Pretoria High Court, which found that the Social Relief of Distress Grant is a permanent feature promulgated under the Social Assistance Act. It was created as a temporary measure, as you may remember, in response to COVID, and a High Court finding that it is now a permanent facility encroaching on the executive power, the state argues in appeal papers filed with the Supreme Court of Appeal. Joining me on the line is researcher at the Institute of Economic Justice, that's Siyanda Baduza. Siyanda, I imagine the IEJ obviously disagrees with the Social Development Minister and SASSA, don't they? Good morning.
Good morning. Thank you for having me.
Do you disagree with the government that there is an encroachment on the executive powers by the High Court in Gauteng that found that the SRD grant is now a permanent feature promulgated under the Social Assistance Act?
Sure. No, we don't disagree. We do disagree, because for a number of reasons, especially on the definition of the grant as temporary. I mean, for one, I think in practice, we've seen that the grant truly isn't temporary. It's been here for at least 7 years now, and it's been extended to March of 2028. And if the pattern continues, it's continuing afterwards. So it's very clear that the classification of the grant as temporary has only been so that it is arbitrarily treated differently from other grants. And then those are the things that I think we'll get into that lead to the grant being unfair. But it's also that, the classification of whether a grant is temporary or not, we don't believe is that significant, because again, it still does not give you the right or make it just for people to be treated unfairly. So it's a fairly arbitrary point.
Let's talk to the merits of the grant, shall we? It is one of the bigger, in terms of numbers of people who are recipients of the grant, that SASSA administers. We do know that Treasury only budgeted 10.5 million, it provided a budget for 10.5 million people when 18.3 million at some point were reliant on it. I believe those numbers have reduced quite drastically due to systems that have been applied by SASSA, and you have some challenges with that.
Yeah. So at the core of the case, essentially, the argument is that it comes down to resourcing, and mainly because the resourcing for the grant did not happen on objective terms. So according to the way in which the government has defined in the policy who should be qualifying for the grant, there are many ways in order to verify exactly what those estimates should be. And the numbers usually come out to 17 or 18 million. And yet, if you only budget for, it's not even 10.5 million now, it's around 8 million, then that's the provision, you only providing for 8 million people. And these regulations, we argue, and the High Court agreed with us, are essentially a way to artificially bring numbers down to that budget cap. So it's a matter of the fact that the grant or the government hasn't done enough to resource its own policy, and in doing so is now deliberately cutting down numbers in order to meet what is honestly a pretty arbitrary cap as well, because that 8 million isn't based on any objective definition of need or the number of people who should be receiving the grant.
Where should the money come from, Siyanda? Which line item should the finance minister take money from in order to sustain this grant to the numbers that you are hoping for?
I mean, the case has also clearly not been about defining what the value of the grant should be. It is rather that the state should make a plan in order to resource its own policy. And when it comes to affordability, for example, because the case that the state has made is that there is no fiscal space, but it's also a case where they haven't justified exactly why it is. It's essentially just been asserted that there isn't any fiscal space. And if you see what happened at the start of the case with this grant is National Treasury essentially argued that any type of increase to the SRD grant would be impossible to advance because there was no fiscal space. And yet in March of 2024, the grant was increased without any prior announcement by 20 rands, which I think came up to almost $6 billion, showing that the fiscal space, of course, can be open. It's a matter of whether the government decides to prioritize a certain policy or not. So the case isn't about defining what the value of the grant should be or exactly how it is that it should be resourced, because those are powers that would fall within National Treasury. It's rather to say that the policy has to be resourced and it has to be progressively done so in order to realize the right for people within, of course, available resources.
Is it not central then to the finance minister's argument that the reason why there's a cap of 10.5 million people is just simply government does not have the resources to cover 18 million people?
That is the argument, but I mean that would have to show why that is. So what we're also seeing is that they refuse to admit the budget into evidence. So that would be something that they would do if, of course, they were making the argument that there is no fiscal space. But of course, arguments around whether there's fiscal space or not are never that black and white. So the state would have to prove that there isn't any fiscal space. They also haven't admitted any evidence into doing so. They've essentially asserted that it's impossible to increase it. But it's also important is because, as the High Court judgment found, is that the case is not about immediately increasing the number of people receiving the grant. So a plan to increase the numbers or to reduce the number of people who are excluded is also sufficient for them to provide, as was the judgment that was handed down the last time we were in the High Court.
All right. All the best with the arguments in the Supreme Court of Appeal today. Thank you very much. Siyanda Baduza, researcher with the Institute of Economic Justice. The Social Development Minister, along with SASSA, will be appealing a High Court ruling that found that the Social Relief of Distress grant was a permanent facility. The government saying that this finding by the High Court is encroaching on the executive's powers, and the IEJ disagreeing with the government.